Hello, everyone, and welcome to today's discussion on the far right's dangerous dark money campaign to force a constitutional convention that would radically rewrite the Constitution and hamstring the federal government's ability to protect our rights and address some of today's most pressing problems. Today's event is co-sponsored by the American Constitution Society, the Center for Media and Democracy, and Common Cause. And I want to just make a few housekeeping notes up top. The webinar is being recorded and will be posted online once the session is complete. If you'd like to ask a question, please type it in the Q&A box at the bottom of your screen. We'll be taking questions after our initial discussion, and we'll try to address as many as possible. Finally, ACS, our co-host for this event, is a State Bar of California CLE provider. So this event has been approved for 1 hour of California MCLE credit. We will include a link in the information to the information on how to file for CL credit in the chat. You'll need to collect 2 codes, which I will read, one now and one later in the session. The first code is autumn. And with that, let's get started. I'm happy to introduce our great speakers for today. First up, we have Russ Feingold, president of the American Constitution Society, former U.S. senator from the great state of Wisconsin, and co-author of Constitution in Jeopardy. After Russ, we will hear from Nancy MacLean, a distinguished professor from Duke University and author of Democracy in Chains. A new edition of her book has just come out with a preface that updates the story to the present and with a focus on the push for a constitutional convention. Finally, we'll hear from Jonathan Maida-Stein, the Executive Director for Common Cause of California, about Governor Gavin Newsom's call for a constitutional convention on gun violence. Thank you all for being here today to discuss this important topic. And I'll turn it over to you, Russ.
Thank you, Arn. It's good to be on with you and the other great panelists and all the people that have come on. So, yeah, let's talk about this question of the Constitutional Convention, the possibility of an imminent call for a Constitutional Convention. Former student of mine, Peter Prindiville, and I wrote a book a couple of years ago that came out last year, which, it basically says this thing may sound good on the surface. A Constitutional Convention may sounds sort of democratic at first blush. It's easy to envision a utopian version wherein thousands of Americans representing the diversity of this country in all forms are present and utilize representative democratic methods to propose and approve constitutional amendments. This is not, however, what the far right, working through a group called the Convention of the States, has in mind. They have in mind basically undoing our federal constitution that we have now it was drafted in 1787, ratified in 1789, and essentially sending us back to something like the Articles of Confederation or worse. That's what they're trying to do, and that's what people need to be concerned about. I want to be clear that I certainly don't think, and my co-author certainly didn't think, that there was anything wrong with people trying to have a constitutional convention. It's allowed under Article 5 of the Constitution. There are 2 ways to amend the Constitution, as people know. The one that's been used and all the times that have succeeded, where 2/3 of both houses of Congress agree on something and 3/4 of the states ratify it. But there's another mechanism, and that is if 2/3 of the states simply apply to Congress for a constitutional convention, the Congress is obligated to call such a convention. Now, that's never happened in the history of our country. It's come close sometimes. In fact, it possibly could have happened right away at the beginning of our nation had they not passed the Bill of Rights, which was, of course, through the congressional mechanism, but were the first 10 amendments of the Constitution. One of the really odd things about Article 5 is that after a couple of amendments early in the history of the country, there were essentially no amendments for 100 years, except, of course, for the absolutely crucial 3 Reconstruction amendments. So people started getting it in their head, and political scientists wrote that the Constitution's done. It'll never be changed. But then the progressive movement came, and the progressive movement was able to partly suggest that there might be a constitutional convention and got Congress to do things like allow the direct election of senators, a woman's right to vote, overturning the Supreme Court's decision prohibiting the income tax, and, of course, prohibition. But this movement, the movement to try to call a constitutional convention, is more directed by the far right. It is financed by people like the Koch brothers, the Mercers, and Steve Bannon's a huge fan of this. So one way to think about this, those that are trying to do this convention now and are trying to get these applications passed, are funded by the very same people who brought us things like January 6th and the independent state legislature theory that they tried to get the Supreme Court to go along with. So that's what you're actually dealing with. And so when you look at the possibility of a convention being called, you have to realize what they're actually trying to do and how they're going to try to structure it. What they're going to try to do, and it's clear that they are doing this because they've had several mock simulations. They just had one this past August, where they bring together far-right delegates who are usually state legislators from all 50 states. They come to Williamsburg and they sit there for several days and they propose amendments and they discuss amendments and then they vote on them. And so we don't have to wonder what it is they're going to try to do if they somehow get Congress to believe that they have enough petitions. What they voted for, and we have voted for consistently, is to completely demolish the power of Congress to act on crucial issues. For example, like COVID, they would take away Congress's ability to deal with that. They would gut the administrative agencies and the powers of our administrative agencies of our country. So that, for example, the Environmental Protection Agency couldn't deal with climate change or clean water issues. And they even have a proposal that at first they said it should take 30 states. Now they're saying it should take only 26 states, where state legislatures, a majority of state legislatures, could overturn any act of Congress or any administrative rule. I call that the John C. Calhoun Amendment. And here's the problem with the way they want to do it, and it shows the way they do it. There is simply no way to limit what the topics would be. They'll tell you it's just going to be about balanced budget, a couple other things, but there's no way to limit it. There's no way to limit it in the Constitution at all. Secondly, there are no rules at all about how the delegates would be chosen. And that's why they're going to try to pull this end run of having gerrymandered legislators deciding the future of our Constitution. And perhaps most significantly, when they voted at these simulations, they don't vote based on all the delegates popularly elected. They just have one vote per state. So that means that Wyoming and Idaho get exactly the same say in what the Constitution is going to look like as New York and California. And of course, we already have plenty of that with the Electoral College and 2 senators per state. This is an attempt to lock in a minority rule against the diverse country that we have in a way that could be very damaging. And we can talk about this more later. But the biggest problem here of all is there's essentially no way to stop it if they can get the Congress to say there's enough petitions. President has no say in it. It appears that the Supreme Court would not have the authority to stop it. So we could have a constitutional crisis of major proportions, which of course is what Steve Bannon would exactly like. So let me leave it at that. Obviously, we wrote a whole book about it, so I could go on forever and filibuster, but I won't. I will turn it back to you, Arn. Thanks.
Great. Thank you very much, Russ. Over to you, Nancy.
Okay, great. Thank you, Arn, and thanks to the American Constitution Society, Common Cause, and the Center for Media and Democracy for organizing this convention. And thanks so much to Senator Feingold for his service. I'm a former Badger, and also for his book and his opening here. In Democracy in Chains, I told the story of a scholar whose ideas Charles Koch and his allied organizations have weaponized in a long game plan of interrelated plays to shackle democracy. If you're watching this webinar, you are probably painfully aware of many of those plays, each one of which reinforces the others. Things like extreme gerrymandering, voter suppression, stacking the courts with ideologues from the Federalist Society, and more. But now their plans have moved into a new phase, as Russ Feingold conveyed, and this phase is laser focused on the Constitution. After a defeat that surprised them in the 2012 presidential election, the radical right launched a quiet new campaign. They had already used dark money and savvy institution building to capture a majority of state legislatures in 2010, so the groundwork was in place for this next phase. The new campaign has been spearheaded by the American Legislative Exchange Council, ALEC, the organization they had long funded to work at the state level. And ALEC member legislators in each state in 2013 were given detailed instructions as well as model text to bring back to their state houses for a resolution to authorize an Article 5 convention. Should such a convention be convened? What is it that these ultra-rich backers want? Russ Feingold shared some of that, and I will also quote the leader of the Convention of States campaign, the former Tea Party activist Mark Meckler, who has said that the purpose is, and I quote, to reverse 115 years of progressivism, to reverse 115 years of progressivism. So how could they do that? How could they do such an audacious, sweeping thing by constitutional amendments? The first one up would be one to require that the federal government balance its budgets annually. Now, because for so many years we have heard candidates equate federal budgets with household budgets, that may not sound like a big deal at first, but it is actually a dagger aimed at the heart of most of what we look to Washington for. Above all, at Social Security and Medicare, both of which the radical right has always opposed but never been able to persuade voters to end. Next up would be an amendment to end federal income taxation, an amendment from the progressive era, so as to prevent Congress from raising taxes on the ultra-wealthy and corporations to cover the programs that the balanced budget requirement would put on death watch without steep tax increases. So together, those two amendments would form a kind of a maw, jaws in which to crush all the ongoing popular programs that cost a lot of money, including environmental protection, as they also ensure that government does what the people have called upon it to do to meet needs that the majority has identified as important. But that wouldn't be all, not just those two amendments, because the convention boosters have never accepted the human rights reforms of the 20th and 21st century. Civil rights for minorities, women's rights, and LGBTQ protections from discrimination. So another amendment that they seek would, and I quote, limit the power and jurisdiction of the federal government. So what they're seeking here is a return to states' rights of the kind of high-handed variety that prevailed before the progressive era amendments, the New Deal, and the Civil Rights era. And of course, they seek an end to the federal government's ability to regulate corporations for the common good. The organizers of the convention effort have made clear something else. The votes taken at such a convention would not be based on population, but on one vote per state, as Russ said, so as to grossly underrepresent the majority of Americans. At ALEC's 2022 policy conference, former U.S. Senator Rick Santorum explained that the plan depends on this disparity. Santorum noted that Republican-run states with tiny populations, and I quote, actually have an outsized power granted under this process. They could wield a supermajority, even though we may not be in an absolute majority when it comes to people who agree with us. So basically what he's saying there is that this envisioned supermajority will include the least populated states in the country, such as Alaska, Wyoming, Montana, and the two Dakotas, some of which have fewer total residents than single cities in the Democratic states that Russ mentioned. Needless to say, the likelihood of anything good coming out of a convention like this is nil. But given the text of Article 5, should enough state legislatures sign on to authorize a convention, there is nothing the rest of us can do to stop the process from going forward. Mark Meckler gloats about this. Once the advocates get to 34 authorizations, he says, and again, I quote, Congress can't stop us. The president can't stop us. SCOTUS can't stop us. And here's the bombshell that makes alerting people to this effort so urgent. And Russ pointed to this. The leaders of this convention push have realized that those last 6 states needed are going to be too hard to win over honestly. And they have convinced their grassroots army, as they refer to it in military terms, with the aid of the right-wing media echo chamber, that today's multiracial, gender-inclusive majority is a mortal threat to their America, so an ends justifies the means strategy is needed. Among the many weaknesses of Article 5, it does not set any time limit on the proposal process. And strategists on the right have concluded that there is nothing that prevents them from, in their phrase, aggregating all the authorizations ever passed by state legislatures for other purposes and still on the books with open-ended language, many of them wholly unrelated to the current one. So with this kind of crooked accounting, the organizers claim that they already have the authorizations needed, and they plan to demand that Congress convene a convention, perhaps as soon as early 2025. And this makes the stakes of the 2024 election far higher than most of us realize. Does anyone think, having watched for some time now, that Kevin McCarthy would stand up to the demand to convene a constitutional convention? I think that's hard to imagine. And that is why conversations like this one are so urgent, to inform the American people of the imminent danger of a constitutional convention before it is too late and while we still have the capacity to block it. Thank you.
Great. Thank you, Nancy. Over to you, Jonathan, talk about what's going on in California.
Thank you, Arn, and thank you to the amazing panelists and the organizers of today's event. The title of today's event, it talks about the right-wing push for a constitutional convention, and I'm here to talk about something of the opposite, a push towards a constitutional convention coming out of California that is not right-wing, but motivated by Governor Newsom and a push for gun control. So as you may or may not know, the California state legislature just passed SJR 7, which was the governor's call for an Article 5 convention to accomplish one or both, either or both of the following. One, to affirm that all governments, federal, state, and local, have the power to adopt regulations limiting gun control, specifically firearm acquisition, possession, public carry, and use by individuals, and all of that would be consistent with the Constitution, or actually imposing specific gun control regulations, universal background checks, limiting the sale to those under 21, a minimum waiting period, and a prohibition on the sale or transfer of assault weapons. The resolution specifically writes in language that attempts to address the concerns that Nancy raised, and I think many experts feel inadequately, to say that this is a single subject call that cannot be aggregated with any other calls for any purpose, and that it becomes void in the event that it is attempted to be aggregated with other calls or general calls. So we opposed. It was a lonely opposition for us at California Common Cause, and I'm going to give you a little bit of a report out on the ground and what it looks like to actually try to push back on a call for a constitutional convention, a live, real one. Over the last many months, the Newsom administration rolled out their call for a constitutional convention with most of the Democratic members of the state legislature already on board as sponsors. And so it was sort of a done deal. A signal to the Capitol community is a done deal from the very beginning. The only opposition was California Common Cause, the League of Women Voters of California, one county, and a gun rights group. So as I said earlier, it was a lonely opposition for us, but we felt we needed to stand on principle because of the concerns raised by Nancy, Russ, and others. And many of the groups that we thought might join us in opposition chose to stay off the measure. So an unrestrained runaway convention that could rewrite basic rights with respect to abortion, for example, is a real danger. And we thought maybe abortion rights groups would join. And I'm not singling them out. This could go for labor or a number of groups that work in civil rights and on the left in a variety of ways. Those groups all chose to stay off the measure, SJR 7, out of, I think, two rationales. One, this thing was inevitable. It was going to pass in California. There was no hope to stop it. And two, that once it got to the federal level, you weren't going to see 2/3 of other states call for gun control constitutional conventions. And so this was inevitable in California, but not necessarily due for any sort of legs or success at the national level. And the sense that it was inevitable in California proved to be correct. We had one Democrat who voted against the measure because of concerns we raised, but literally that was it. It's received support from the rest of the Democratic caucus and flew through the state legislature and was passed earlier this month. In 2014, California actually already passed a single subject call for a constitutional convention to address money and politics issues and overturning Citizens United. And so given that, where does our concern come from? Well, the first, of course, are the issues that Nancy and Russ have already raised, which is that a runaway convention you can't limit necessarily, or at least there's reason to believe you can't limit the call for a constitutional convention. We could have a runaway convention that leads to bad outcomes on a range of issues and basic rights. But also, if there were to be a constitutional convention called on the subject of gun control and gun rights specifically, if you assume that every state would have an equal vote, you probably would get loosening of gun control instead of a tightening of gun control out of this whole experience. It would achieve the opposite of what the governor had hoped to see. And I mean, I'll just take this down a very, very short rabbit hole. The fact that there are no rules around a constitutional convention and there's no procedure around a constitutional convention applies to issues of lobbying, influence, money in politics, transparency. All the issues that Common Cause cares about in the context of our regular government would be just as present and probably more intensely so at a constitutional convention. We would have no idea who's seeking to influence the members of the Constitutional Convention, what lobbying would be happening behind the scenes. Would there be public records requirements? Would there be transparency requirements? We just have no idea. And then additionally, and finally, we have concerns about the California call for a constitutional convention on gun control popularizing calls for an Article 5 convention among blue states as a policy tool. California is often a policy leader, particularly in areas where we see inaction or gridlock out of our federal government. And I think it's easy to argue that we've seen inaction and gridlock out of our federal government with respect to gun control. And so what we don't want to happen in a world in which so many red states have already called for constitutional conventions, and according to the fuzzy math that Nancy mentioned earlier, we may or may not be close to triggering, the relevant triggering thresholds. We don't want more blue states using constitutional conventions as a way to implement certain policy goals. And so this, we fear, raised the specter of that going forward. So we stood in principled but lonely opposition on SGR 4 and watched ourselves lose as it flew through the legislature and is now on the books for California.
Great. Thanks so much, Jonathan. So I think we'll take some time now to have a little discussion between the panelists on some of these issues, and then we will open it up for questions from our viewers. I guess I want to pick up on what Jonathan was saying and just throw it out to you all. I feel like some of the disconnect here is that people have an image that a constitutional convention would be an exercise in popular democracy. But could you address for a bit like what the math and the dynamics would look like in a convention as envisioned by the right, where delegates are chosen by politicians and each state gets one vote?
Yeah, I mean, if anybody thinks that the concurrent proceedings of the various gerrymandered legislatures in the country are popular democracy, then they might like this. I mean, in Wisconsin, we've had statewide Democratic victories in 2018, 2022, and governor, lieutenant governor, state treasurer, attorney general, and we keep losing ground in the state assembly and state senate. These are the people that would purport to set the rules for this. In fact, as Nancy pointed out, ALEC has a model piece of legislation that Wisconsin passed that says exactly how this would work. So I don't know how people on the left, whom I of course respect, look, you know how I feel about Citizens United. My name's Feingold. I'd like to see something happen here, but it's a pipe dream to think that with Kevin McCarthy calling the shots in the House and potentially McConnell calling the shots in the Senate, this is the scenario we need to worry about in 2025, that's the way it would play out. It would be an incredibly unrepresentative return to we the states instead of we the people.
Yeah. I'd like to ask Russ, your book has been out for a bit now, and I'm sure you're doing a lot of traveling and speaking and talking about it. And I don't know if you're finding this, but I have found this, when I've been speaking to audiences, that almost no one knows that this is a thing, right? That there is the possibility of a constitutional convention. And I think, our eyes have been focused elsewhere, for the last several years, so many different things going on, but as valiantly as Common Cause has worked and CMD and, ACS, people just don't know enough about it. So I'd be interested to hear about what you've been experiencing, as you're speaking about this, and also if, for example, ACS chapters are starting to do popular education about this to alert people in their states to what's happening.
It is happening. Just back from most of the week in Texas with 5 of our chapters, Arizona and others. But look, I was teaching in law in 2010s. I didn't know really about this. I had been chairman of the Constitution Subcommittee in the Senate, and I didn't know about it. And I looked around. I was teaching a course on the U.S. Senate, and I thought, well, what about Article 5? And I found out that no law professor had ever taught a course on Article 5, and in particular about a possibility of constitutional convention. So look, I didn't even know what was going on with it. Nobody did. And when I asked people for blurbs about the book, I asked some of the top constitutional scholars in the country who were honest enough to say, I didn't know about this. This scares me. So, we had 1,000 people sign up for this. There's a sign that people are catching on. But you are absolutely right that it's just something that people are awakening to.
Great. Thank you both. We have a question from the audience asking, can someone explain the current count and how many states are needed to call a constitutional convention? And did California add to this count? So, and I would like to just add to that question to have you address Alex's strategy of aggregating different convention calls. Russ, you want to start?
I'm happy to say, this is the ultimate fuzzy math. It's supposed to be 2/3 of the states applying, and it's quite clear that the founders expected that they would be similar applications. So look, if all 34 states say we want a whole new convention or a whole new constitution, so be it. That's adequate. That's not what's happened. What these folks are doing, Convention of the States and others, as was pointed out by both of the other speakers, is they're aggregating things like calls to end slavery from the 1850s with term limit applications, with Wolfpack Citizens United ones. So they're asserting the notion that somehow you can just mix and match these, throw them together, and that meets the constitutional requirement. So I think it's fraudulent. It's not right. But as Jonathan pointed out, who's going to stop it? The Supreme Court doesn't appear to have the authority to step in and stop it. So that's the part about this aggregation that's so disturbing.
I will just add too, since the Federalist Society has been much in the news with Leonard Leo's work to try to capture the Supreme Court and federal judiciary, that it's worth noting that one of the main rationales for this aggregation was on the Federalist Society website. So, so that I think is important to keep in mind and keep an eye on the Federalist Society, because they very much, as Russ was mentioning earlier, have come up with things like the independent state legislatures doctrine or theory to try to find end runs around the people in elections. So I would just add that, to keep Federalist Society activity on your radar and look into that.
And I can answer the specific question of whether California has added itself to a pile to get us closer to 2/3. As I mentioned earlier, California was already on the books with a single subject call for a constitutional convention to address money and politics issues and to overturn Citizens United. What that means is that a single subject call comes with all the caveats that have been discussed over the course of the last half hour. We're not clear that a single subject call is a thing, and there are attempts to aggregate single subject calls with larger, more general calls in order to get closer to 2/3. So California is already part of the count if the count can be mixed up together. And this additional one doesn't take us incrementally closer. And we recognize that, and we recognize those points made by some of the supporters of SGR 7. But our main concern was the last thing I mentioned in my remarks, which is that this has the power. SGR 7 in California had the power to take this out of the shadows that Russ and Nancy were talking about moments ago, and in blue states make it a thing, make it something that blue state lawmakers decide they want to use if they want a big, splashy, bold push towards policy reforms that our federal government is incapable of achieving.
On the positive side, Arn, I want to add that, and I think Nancy points this out too, states can rescind their applications. And in fact, Illinois a few years ago, which actually was a much more conservative state when I was growing up, and Wisconsin was a more liberal state, they just said, wait a minute, we don't want to be part of this. And the legislature repealed it or rescinded them. Oregon did that a few months ago. So this is almost like a very kind of fascinating chess game where some of the blue states are realizing, wait a minute, we don't want to be sucked into this thing. So that they can't count those anymore, at least. It would seem that they wouldn't even try to argue that, but God knows what the approach they take.
Yeah, my understanding though too is that thanks to the hard work of the partners who organized this, Common Cause, and I know Common Cause has worked in states like mine in North Carolina and other places on these issues. But I think that all the rescissions that are likely at this point have happened, and that so now we're down to kind of a hardcore group. I'm not quite sure though. At one point, this aggregation was so ridiculous that they were including New York State's call for a constitutional convention to ensure that the Bill of Rights was added to the Constitution. I mean, so it was that old and that unrelated to this. And I know that there were people in the New York legislature, prompted by New York Common Cause, who were working to get a rescission of this, but I'm not sure where that rescission stands. So maybe Arn, could you answer that? And also perhaps Arn, since you're the moderator, but you haven't, had much of a chance to put in the kinds of things that Center for Media and Democracy has done. Maybe you want to say also some of what, the resources you have on the Center for Media and Democracy, that you've put out to help people understand this and know about the voting procedures and such.
Well, sure. Thanks, Nancy. So first on the rescission issue, New York did rescind, if I believe. But Jonathan can correct me, or someone can correct me in the chat if I'm wrong. But there have been 7 states that have rescinded. And that's certainly a help. I mean, ALEC has been the group that's been leading the charge on this argument that you can aggregate a number of convention calls, and they take the position that the requisite 34 states was reached decades ago, and that Congress is derelict in its duty. So there was a lawsuit last year called McCall versus Pelosi that tried to use the courts to force a constitutional convention. That was dismissed on standing grounds, but also, the court flagged that it was a political question, which is probably the most likely way. That my assessment is that it's I'd be interested to hear others, that it would most likely be courts would defer to Congress on this one, which is why who controls Congress is such a vital question when it comes to this. In terms of resources, we have, and we'll circulate for attendees later on, a report called Convention of State Politicians, which describes the right strategy for how delegates would be chosen and what that math looks like, and how voters would have no say in a constitutional convention.
Yeah, I think any Supreme Court would probably take a look at this and look at the Constitution and say it's not justiciable and it might be a political question, but especially this Supreme Court, who some of them are basically disciples of some of this kind of thinking. So one would hope that somehow the Supreme Court could step in and say, look, you literally don't have 34 petitions that are adequate to do this, but it doesn't appear that authority is there, or that they would do it. And that's one of the most frightening things about it.
Yeah, we did have one question about what the actual count is currently. So I'll just say, aggregation aside, the folks who are pushing for a balanced budget amendment claim 28 states. Some of those have been current, some are back from the 80s. convention of states has passed their resolution in 19 states. And interestingly, convention of states does not support aggregation. It's ALEC and the balanced budget amendment folks who are really pushing that strategy.
Worth pointing out too, since we mentioned Wisconsin, Russ mentioned Wisconsin earlier, that Scott Walker was leading one of the, after being sent packing in an election, was leading one of the Constitutional Convention efforts that was focused solely on the balanced budget amendment.
In fact, he declared at a press conference that wasn't supposed to, it wasn't a press conference, but a meeting that he didn't think was going to be revealed, that they already had enough applications and they should go ahead and do it.
I think, maybe one thing that I would say here too, because I see, there are a lot of questions in the chat about the rescission process and what that means. And I think what we're seeing now really, really underscores the need to pay attention to what's going on in your states. And if you're concerned about this, to be active in your states. And I know, Common Cause, for example, has chapters in many states like mine, North Carolina, where folks are working on this. But, essentially any state that changes, any state legislature that changes hands could then be approached, if they've already authorized, for a rescission. And I do know, I know we're in 501c3 territory here. I always wonder how that works, but I do know, for example, that the Biden campaign is putting significant resources into North Carolina and a number of other swing states. If that were to happen, that would open up prospects for rescissions in some of those states. So, I would also say, just in more general terms, that we have reached this kind of dire position that we have gotten into, despite being with the majority on so many issues, because people on the progressive side neglected state politics for a very long time, right? And focused on national politics and oftentimes on local politics, and did some very good progressive things in cities. But what we've also seen is if you have a city that, say, passes an anti-discrimination ordinance or an environmental ordinance or, what have you, that if you have a legislature that's dominated by these conservative activists, they can preempt those measures, as they have. And the governors in Florida and Texas, for example, preempted smart public health policy during COVID. So that failure to focus on the middle level, the state level has really, really hurt our people and our issues over time. And I think, many people did start to realize that, ironically, after 2016, and we saw a lot more participation in midterms in 2018, and then again in 2022 in many places. So that's encouraging. And I think more and more people are paying attention. But I think this issue is also a way to galvanize attention and to make people realize that the stakes in 2024 are so huge. We already knew that they were huge in many ways, for things like action on the, climate collapse and so forth, the future of democracy. But they're also, these 2024 elections are also crucial for whether we are going to maintain a constitution that is in any way responsive to the people.
Nancy, what you're saying is so important, because people say to me, well, what can we do about this? They get nervous enough. Well, it's more important you talk to your state legislators or people running for the state legislature, the members of Congress. Look, if a certain party gets the House and the Senate, they're just going to probably do this. But if there aren't enough applications, it's at least a possibility that they won't be able to act. And so just talking to anybody, even a very conservative candidate for the state legislature, can work. Keep in mind, and this is important in terms of whether this is really partisan, in a number of places, very conservative groups don't like this. The John Birch Society doesn't like this. The Eagle Forum doesn't like this, and they stopped it from passing in Montana once. So, this is a strange bedfellow situation. But they're nervous that, people like Gavin Newsom would set the agenda. Look, if you really believe this is unwise and that there aren't any rules, it's talking, as you just said, to your state legislators and candidates for the state legislature in 2024 that is so important.
And let me just chime in to note, there's been a lot of talk about Common Cause's very good work on rescissions around the country, and I want to politely decline any credit for any of that. Vicki Harrison at our national office is doing amazing work organizing that work across the country, and my colleagues, one of the beauties of Common Cause is we have these state chapters that enable us to really dig in with local expertise. And we have my counterparts in other states are leading some of the work to to pursue rescissions, which is, I mean, it's hard and thankless work that is totally under the radar, but utterly necessary.
I want to maybe say something too that picks up on where Russ started out, because just looking at the chat, I can see that there's a kind of hunger for the kinds of constitutional amendments we need, that would do things like address Citizens United, or that would, enable us to do the things that so many want to do. So we are presenting a very frightening view here, but I also want to do a little plug for another book, The People's Convention, by our colleagues over at the Brennan Center, John Kowal and Wilfred Codrington. And they point out that the texts of the amendments, what they call the People's Constitution, at this point is actually longer than the original Constitution, through generations of citizens proposing amendments. But they also make the very interesting point that if you look at the pattern of how amendments have passed, they have tended to pass in clusters after times of, significant social and economic change, when, the old framework doesn't really match where the people are and what's happening in the world and what we need done. And so they make the case in the end, and they do talk about, the threat of this constitutional convention, predominantly from the right, but they also make the case that we're due, for another round of amendments, of the kind of positive, enabling amendments of the living Constitution that we have seen in previous generations. But they also, make the case that these should go through the normal amendment process that we're familiar with, that gets lots of sunshine and exposure and discussion. So I just want to add that in there because, again, it's not like we think that the Constitution is an absolutely perfect document, as it's written now, and that there isn't room, to address some of the pressing issues that we face now, particularly in the wake of recent Supreme Court decisions. But I think we would all agree that the way to address those is to go forward with new amendments, in the classic way. And it's a steep uphill climb, but it is something that can be done and that needs to be done.
This is crucial. And in fact, our book is called The Constitution in Jeopardy. We think there are twin jeopardies. One is the one we've been talking about. The other is it can't be changed, except for extreme difficulty. There hasn't been an amendment since 1992. And that's for the reason you just said. Trying to get 2/3 on anything is so difficult. So what Peter and I proposed, although we didn't do it in great depth, Article 5 needs to be changed. It is the hardest thing in the world to amend, or to amend the Constitution in the United States. It's the hardest in the world other than a constitutional convention. And it's too hard. So we propose that maybe the standard could be brought down some in terms of the vote in the House and the Senate. We also propose that a bipartisan commission propose that legislation be allowed that would make rules for a constitutional convention. That there would actually be issues about how votes would be done, how delegates would be chosen, how you could limit it. And so, but that's an uphill climb too. But a bipartisan, not specific issues, a bipartisan process to create that kind of a constitutional amendment is essential because the Constitution is becoming ossified. We got to get rid of the Electoral College. We need a right to vote. I like to kid around and say the founders were not very good about climate change. They didn't really have any real provisions in there. So something has to give on that side. And the progressives who say that are right.
So we have a question that relates to that, which what legal authority would govern constitutional procedures and who gets elected as delegates? And so I think it's just worth, because I think people have a hard time grasping how little is in Article 5. So you want to address that? And I guess I will add to it and say, what would be the implications if you have a number of states that pass resolutions saying that their legislatures get to appoint the delegates, and it's one state, one vote, and then you have a Congress that says, no, we get to appoint the delegates, and it's population-based, for instance. So I'd like to at least explore we've had a lot of constitutional crises lately, and what are the potentials here for a constitutional crisis if there's no consensus on the rules of the game?
Well, there's a tremendous problem, and the biggest problem is there are no rules. The Supreme Court needs to be able to look at some language, first be able to feel that they can be involved, and secondly, there's nothing there to guide them. And so it appears that we would have a constitutional loggerheads, if you will, or stalemate, if there were sort of two groups of delegates competing, and where is the authority for the Supreme Court to say, this is the valid convention, not this one? It doesn't appear to exist. And that's why you have to do something to amend Article 5 to create these rules. I don't think there are any.
Mm-hmm. I would just add too, from my handy little ACS pocket constitution. And I have had the same experience with Russ, by the way, and I won't name them, but I spoke once to a board of a rather large foundation, and there were two Harvard law professors on the board. And as I was speaking, they started going on their phones, and I thought, oh no, I've lost the audience. Like they're checking their email. Well, it turned out they were actually checking the Constitution and Article 5 because they had completely forgotten that this alternative route existed. But if you look at the text of Article 5, it is only a paragraph, and 6 lines of that paragraph, almost a third of it, is actually devoted to making sure you can't end the slave trade before the dirty compromise that they had made to extend it into the 19th century. But there are literally no rules on this, right? And so when we say that, we're not inventing it, urge you to go to the Constitution, look at Article 5, it's there, and that is why, conservative legal figures, such as Warren Burger, also said there's no way to effectively muzzle or control a constitutional convention. So I think, in the old days, a more conservative legal profession and academy and judges would have put the brakes on this. But now what we're talking about is essentially radical reactionaries in charge and pushing for this. And to them, it's appealing that there aren't brakes on this, that there aren't rules, that they can craft the rules, that they can decide who the delegates are, and there's nothing to stop them from deciding they want to change how ratifications are done afterwards. So again, we are into really frightening territory with this, and most of the country would feel absolutely blindsided by this. So there's no telling the kind of explosive situation we could get into if the right continues pushing on this, and the rest of the country doesn't even know that it's happening until it's almost too late to reverse it. So that's why, again, I am really glad that this conversation is happening early on, that these resources are out there for people to educate themselves. And I do know that Common Cause had something like 200 organizational partners on its document against an Article 5 convention. But I think given the number of pressing issues organizations have been dealing with, over the last decade and more, some of that may be a kind of paper support, but there might be ways to, to use a conversation like this to go back to those organizations and say, what states are your members in? This could be true of unions too. What states are your members in? Could they be active in talking to legislatures and trying to seek these rescissions where possible? So I think there is a great deal that we can do if we start early. And the little bit of good news in having this forum, I think, is that it does help us to launch that kind of effort.
Just to illustrate the mysteriousness of this and how far back it goes, they added this convention provision basically 2 days before, on September 15th. And Madison didn't oppose it, but he says in his notes, he saw no problem with the convention, but believed that, quote, difficulties might arise to the form and the quorum, which in constitutional regulations ought to be as much as possible avoided. In other words, he basically was saying, nobody has any idea how this is supposed to work.
Yeah. It's also worth noting, and I do point this out in the new preface to my work, because I, like you, I went back to the Constitutional Convention notes, to Madison's notes on the convention, to try to understand where all this was coming from and how it got in and the process. But it is very interesting that the proposal came from George Mason, who ended up voting against the Constitution, he left the convention in a huff, and he ended up not ratifying the Constitution. And the reason he said there should be this alternative route to amendment is he said the federal government could verily become oppressive. And this was somebody who held 300 people in bondage, and whose idea of liberty included the economic liberty to keep those people enslaved, knowing the national society and a government of we the people would in time turn against it. So I think it's really important, particularly in our moment of dealing with systemic racism and, so many things that we have been more in the forefront of our conversations in this period, that we realize that the most anti-democratic and some of the most dangerous elements of the Constitution are there because of the most extreme slaveholders. And actually, as you point out, Madison was like, what? But on the other hand, they all wanted to get back home because it was.
Let's worry about it later.
It was hot. It was 3 months. It's really quite an interesting story.
On the subject of Common Cause resources, Nancy's mentioned this, but there's a link in the chat now, Doris. Thank you for putting that there. It's a link that holds Common Cause's work on the topic. And if you scroll down to the bottom, you can find the coalition letter signed by almost 250 organizations in opposition to an Article 5 convention.
Yeah, and I'll add that Common Cause has a great report probably linked on that page called Constitutional Chaos, which really covers the ground well in terms of what groups are trying to do what. Back to something Nancy was saying earlier on this, I just maybe it's a good time to circle back around to what the stakes are here. We clearly have a far right that's frustrated at not being able to dominate Washington, and they're looking at the math of a one state, one vote convention where they could potentially have a supermajority. At their mock convention this summer, Convention of States delegates, who are all Republican legislators, even from blue states, adopted 6 proposed amendments to the Constitution. I may miss a couple running through them here by memory, but they included term limits, limiting the size of the Supreme Court to 9 justices, basically taking the Commerce Clause back to the pre-New Deal days so that the federal government doesn't have authority to regulate civil rights or the environment or any number of other things. As Russ mentioned earlier, allowing a simple majority of states to overturn any act of Congress or any federal regulation that they don't like, sort of new confederacy of sorts. And maybe in reflection for a lot of the oil industry money that is behind this effort, one of the proposed amendments was that the federal government could not own any land or mineral rights without express permission from the state legislature. Does have any reactions to that?
I will say that since Democracy in Chains came out, I understood that Koch Industries was a fossil fuel corporation and that stopping action on the climate was among their most important drives. What I've understood better since then is how absolutely central that is, that they have seen the Koch Industries and other dirty industries, as Senator Sheldon Whitehouse calls them. He's been great on all these issues about climate and the courts, and has a great book on the Supreme Court, by the way, called The Scheme. But their determination to stop us from addressing imminent climate collapse has been crucial in all of this. So in Democracy in Chains, I saw, the big rollout when they really got serious and started putting in so many resources and coordinating in a significant way was in 1997. And thereafter, well, that was also the time of the Kyoto Accords, right? So they saw an existential threat to the future profitability of the fossil fuel sector. And since then, it's also been clear, I've learned that they're doing much more about this internationally. So I think that climate connection is much more central than I had realized before. And I think it's something that all of us need to be aware of, particularly as we're all facing, the turn to really extreme, terrifying weather with the horrific fires and floods and, hurricanes getting more and more frequent and more devastating, that these are people from these dirty industries who do not want us to be able to use our democracy to address even this fatal challenge that we're facing. I mean, people are already dying as a result of this. Certainly species are dying, animals are dying, the ecosystems are in dire trouble. And so I think we do need to have that bead on who we're up against and how serious they are and how determined they are, because that tells us that we're going to have to work really hard, because it has always been through our history. I teach the history of social movements. If you have the power of money, you need the power of organized people. And so we have got to build on the great organizing that's already going on in the country, but really expand that, do much more popular education to help people see how high the stakes are and how crucial it is that we have a responsive government and constitution.
I think the connectivity of these efforts in different forms is crucial. Nancy's bringing out. Maybe people say, well, let's not worry about this convention. Well, it's all the same thing. It's corporate domination of the Supreme Court. You might say, well, there were a couple of decisions that weren't so bad, but the thread that is consistent is the corporate control that this Supreme Court supports. And these things, the most popular things at these simulations, are of the same kind. It is an attempt by these corporate interests in the country that want to dominate things and stop us from solving some of these problems that are using all these tactics. And they are interrelated and they are financed by the same people.
I need to jump in for just a second to say that for those people who are seeking CLE credit for today, the second code word is pumpkin. Maybe just one last question. We're running out of time. We have a few minutes left. Maybe just one question here, and then whatever you have for closing thoughts would be great. A number of people asked, how does the effort to recognize the Equal Rights Amendment as fully ratified impact the effort to stop a constitutional convention?
I think it's completely different. It's ratification. I happen to be in close alliance with Feminist Majority and others who believe that the amendment has already been ratified. That the Congress does not have the power to have external time limits, and that in fact, when Virginia became the 38th state to ratify, it became the law of the land, and the Biden administration should publish it. In fact, there is now legislation in Congress that basically says that, to acknowledge that it is so. It is not the same as these applications, which can be rescinded. Ratifications are a different story. So it's a separate topic, but it's a very timely one.
Great, thank you. I do want to just point out, if folks want to go back and check on Google, the House Judiciary Committee held a hearing on constitutional amendments that focus a lot on the Constitutional Convention strategy last week. And there is a bill in Congress that would basically calls for Congress to say that the requisite number of states have been reached and to call a convention. So that's, that bill is currently sitting there, but I think, this gets back to, control of Congress. I don't think there's anything the courts are not going to step in here. So it's really going to come down to a political question about how and when people decide that we have enough to call a convention.
Yeah. I would say, maybe just for my last input into this, first of all, thanks so many people for coming and for staying on, and then apologize. There are far more questions that we could possibly have answered within an hour, but lots of good questions are in the chat. And so I trust that our host will save them, and maybe among the resources that Common Cause and CMD and the ACS have on their websites about the convention, maybe they could distill out some of the questions that a number of people had in some form, and just do kind of common questions about the Constitutional Convention, and provide some brief answers so that people do get answers to the questions that we weren't able to get to.
And I just want to say thank you to everyone for the opportunity to speak today. Thank you for folks for showing up. I want to sympathize with the people listening. The challenges to our democracy feel so overwhelming in this moment, from voter suppression to money swamping our politics to gerrymandering to rising authoritarianism. The idea that you have to care about one more thing just feels so hard. and is frankly so annoying. And yet I urge you all to reach deep in that well of optimism and resilience you have within you to also keep your eye on the spread of calls for constitutional amendments, including in blue states, because it's a critically important democracy challenge.
Let me just finish on an optimistic note, Arn. A year ago, when we started our book tour, basically nobody had ever heard of this. Now we're hearing about it all the time. Look at all the people on this call. The effort at public education and making people aware of this is succeeding all over the country, and the brave efforts in California, which is a whole different type of way to have to deal with this that you've had to deal with, Jonathan. The movement to question this is beginning to work. So I thank Common Cause and I thank my fellow participants.
Right. Thank you all for being here today to talk about this important issue. And thank you for everybody for tuning in. We will be sending around a link to the video later, and also some of the resources that were mentioned on this call. So thank you very much.